Hello, it's Philip Taylor speaking from Richmond Green Chambers, and this morning I'm reviewing a book which has come to us from Oxford University Press. It's the Blackstone Employment Law Practice, now in the year 2014 edition. There wasn't one last year. We have reviewed this book before, and it's an excellent book for those involved in tribunal matters and those needing an understanding both as practitioners, advisors and people involved in the tribunal process. It's been edited as usual by Gavin, Mansfield, Queen's Counsel, with a whole range of contributors, and I'll look at the book in a minute. We've given it the title, Among the Best Practitioner References for Tribunal Hearings, now in a brand new edition, and my wife Elizabeth and I have reviewed this work. Here it is. It's quite a heavy, it's a paperback, but it's quite heavy. There's the front, spine. Then you can see the back. I'll just move it up a bit. Quite a lot of detail there. It's from Oxford University Press. There's some very useful little shading on the side so you can find things quite quickly, because it starts off basically with the procedure, which is the main shaded bit there. Let me go to the back first of all. There's some quite useful references on the inside back cover, which again is quite helpful. This is a practice, the same with the front. This is a practice which hasn't been adopted, and I think it's quite helpful for anybody who's looking very quickly for things. Now we're up to just over under 1,000 pages. You can see the actual index there, which is a detailed one. And then there are a lot of appendices, Appendix 9 there, but obviously then we get into the bulk of the book. As I say, the shaded areas help you. The shaded areas also indicate at the beginning where the appendix start. There's Appendix 2, selected legislation. You can see the marking there on the side. Then you've also got, of course, Appendix 1 has the Equality Act itself, and then we start after that, including not just the Equality Act, but quite a large amount of additional information. I'm just getting to the relevant page here. That shows you the actual legislation that's incorporated into the book itself, which I think is of great help. Now what you have got is a lot of paragraph numbering at the sides, extremely helpful to find things very, very quickly. You've got a lot of case law, of course, to be expected. No footnotes as such at all, because they're not needed for a book of this nature. There's the front, and you can see all the names of the people who've been involved in this publication. Then you've got an interesting foreword. That was actually to the first edition of the book. And then you've got a preface to the current edition, which is there. Do read the preface, because that will give you an indication of what has changed in the last year or so. And the main one is the Employment Tribunal rules, which I'll mention in the review itself. You've also got some acknowledgements about various things that have taken place. You've got the actual contents in summary form. There are quite a lot of those. I'm not going to go through all of them. Then you've got the substantial case law. And then after that, you go straight into the various parts of the book. The book is split up into different parts, as you can see. And for each part, you have a little mini index at the front which explains what's in each chapter, with a summary, then an introduction, and then a whole range of points, and then at the end various other matters which are directly relevant. I think you'll find the whole thing, certainly fees, are very interesting. I'm sure your clerks were very interested in that. It's a good book, 1,000 pages, always worth having. It's something that you want to take with you if you go into any tribunal hearing, because you never quite know what they're going to throw at you. Do be aware, of course, that quite a lot of the tribunal presidents and the people who comprise the tribunal are pretty experienced. Some of them are editors of these books as well, so they know what they're talking about. So just bear in mind that you're talking to people who've probably written all this stuff in the first place. It's happened to me, and I'm sure it's happened to some of you, so do be aware of that. This is what we say about the book anyway. Since the first edition of this highly regarded work appeared in 2006, employment lawyers and judges as well have reputedly felt a lot more confident in court or before a tribunal, knowing that they had it close to hand. And this new 8th edition from OUP maintains its established reputation for reliability and authority. And as employment law is characterized by frequent and relentless change, it's virtually imperative, if you're an employment lawyer, to acquire the latest edition, and that goes without saying to all our law books today, because the law is in a state of change. You must keep up to date. There are a number of texts on employment law out there in the marketplace, but this is the only one we feel that provides everything you as an employment lawyer need in the management of a case, including defending and appealing it, and all in a single volume. None of this sort of stuff with all the loose leaf. So not that I'm denigrating loose leaf works, but this is actually useful because you can carry it in your bag. The editor, Gavin Maxwell, Queen's Counsel, who has, in fact, it's not Gavin Maxwell, it's Gavin Mansfield. I got that name wrong, I do apologise for that. Gavin Mansfield, Queen's Counsel, heads a team of 10 expert contributors, including 2 consultant editors, all employment law specialists, whose accumulated knowledge and insightful commentary is placed at your fingertips in a clear and accessible manner. This edition for 2014 incorporates all the key developments in employment law that have emerged since the previous edition was published in 2012, including what I alluded to earlier, the new Employment Tribunal Rules 2013, which constitute the key change for this edition. There are, of course, changes to the EAT, Employment Appeal Tribunal Rules, and those introduced by the Enterprise and Regulatory Reform Act 2013, together with a new fees regime, which are also included, and you'll be aware of the controversy over the change in fees. Of particular interest, we think, is the new chapter on whistleblowing, widely regarded of late by a number of academics as a whole new, distinct and separate discipline in itself. Also, do note the chapter on the types of non-statutory claims typically litigated in the High Court. So in all, this book provides clear and comprehensive coverage of practice and procedure in the civil courts and tribunals, including the EAT and the Central Arbitration Committee. Busy practitioners, we think, will appreciate the clear page design of what is actually a hefty but handy volume, as well as the procedural checklists and the numbered paragraphs throughout, very much in keeping with the Blackstone house style, if you like. The content summary is followed by a detailed table of contents and a 10-page index at the back. And here's a distinctive feature, namely the useful references to substantive law on the inside front cover, and on the inside back cover, the quick reference to procedure, from the claim form and time limits to hearings, costs and appeals. Always useful to have that in case something is thrown at you as a bit of a wobbly when you're about to go into court and it may be something you haven't thought of. So do have a look at those, and they're very easy to find. The book also contains over 50 pages of tables of UK legislation, European and international legislation, codes of practice, practice directions. And anyone befuddled by acronyms will applaud the lengthy list of abbreviations, again extremely helpful. There are 12 appendices as well, a resource in themselves, which include practice directions, codes of practice, forms and precedents, and financial information. So it's small wonder that this book remains one of the best practitioner guides for employment tribunals, and the publication date is cited at the 1st of March 2014. Let's just have a quick look at it again. Make sure I get the name of the man right who wrote it, Gavin Mansfield, Queen's Counsel, and the contributors. You can see them on the spine there. Again, as I say, it is a handy book. It's a heavy book, and there's a lot of detail. Right in the middle of it, chapter 28, deductions from wages. Unlawful deductions. That's, of course, a very key point if you think about employment law, because if when they deduct unlawfully, that normally means they've got no defence as employers. So you should be well on your way to getting a victory. Very useful chapter on remedies as well. Sometimes people misunderstand the remedies that are available, but this is a very useful chapter in its own. And of course you've got things like bias and improper conduct of the hearings. You do get that from time to time. These hearings, the tribunals, are not the same in many ways as the courts at all. There are the cases, you can see this. Just bear in mind that tribunals are meant to be nice and informal. And I've found some of them to be far more formal and far more sort of twisting themselves around in little corners on minor points and detail than some of the stuff that you get in the county courts. It's only an observation I make, but certainly that's something that I know colleagues feel a bit about too, because the concept of the tribunal has seemed to have changed over the years. Now, I'd like to thank the team who've produced this book and Oxford University Press for an excellent new edition. It's invaluable for the employment law practice that you will have. Thanks to all. Bye-bye.